As people know, Wilson Sonsini is a top law firm. Ken is here in Los Angeles. And Ken, you have been a wonderful resource to me, to the community. I know Ken is someone who is always ready to help. And this session is called Startup and Financing Tips. I'm definitely eager to listen. I think when I first moved to LA, Ken, you were one of the first coffees I had where I asked you all of my questions on how this business works. And you have been extremely generous and helpful. And I believe you do know everything about this business. So great to have you here. I will turn it over to you to lead our next session.
Well, thanks so much, Minnie, and thanks for all that you do for the community and for being a wonderful moderator for this conference. Thanks also, to the Alliance for SoCal Innovation, to Andy and Eric and the whole team for putting together this invaluable event. So we couldn't be more excited to be part of this conference, and happy to chat a little bit about startup basics and financing basics for those who may be interested. Now, interestingly enough, this occurs during the lunch hour. So the objective of my presentation is to really get people excited about the legal aspects of startup basics and startup financings, as opposed to creating indigestion. So as a takeaway, we hope that this provides some food for thought. And really the goal of this presentation is to help issue spot and identify some things that investors, VCs, and acquirers will look at in connection with potential investment into the company, as well as things that just irrespective of whether or not you are looking for outside financing, things that are helpful to help increase the value of your company and to smooth the pathway from a legal perspective. So with that, why don't I share my screen and we can go into the presentation.
Ken, are you having an issue sharing the screen, or is it are we letting you?
If you like, I can send you my my deck, and that may be helpful as well.
Let's just make sure. See on our end if it's permission setting. Hold on.
And Ken, you usually work with companies just when they're early phases through later stages. Is that true?
That's exactly right, Minnie. So one of the wonderful aspects of working in Southern California is the ability to work with companies of all stages. So just by way of example, I've worked on a few incorporations this week. I've closed a few financings, and this ranges all the way to companies that I work with that are in their IPO stages. And so it's a wonderful ecosystem here, both in the context of life sciences, tech, and other industries. And our firm is specifically designed to be able to help fast growth companies, not only from their incorporation, but maybe their first round of financing to ultimately going public and helping them as a public company. It was really rooted, and there are a few slides about the firm, but maybe not to go right into the substance of the discussion. It really comes from the DNA of our founders. Who took a long view of representing companies and as well as investors and funds through the tech ecosystem. And so, one of the most notable companies that the firm took public was Apple back in the 80s. That then created a momentum, or perhaps that was part of the momentum that allowed the firm to represent Netscape in its IPO. To incorporate Google and take it public as a former Google alumni yourself, and then also to represent really innovative entrepreneurs throughout Southern California and Northern California and the world, including taking Tesla public with Elon Musk and Twitter, and Square public with Jack Dorsey, as well as companies here locally in LA and San Diego. Including Illumina, for example, Blackline, Revolve, and others. So So we've been very fortunate to be able to have seen a number of issues that have arisen, and really the goal of today's presentation is to identify an issue spot, so that each of the founders here can get a sense of what to look for as they start to go towards a track of financing, and hopefully ease the pathway in terms of making the due diligence smoother as they start to speak with investors and venture capitalists. So, Steve, I don't know if it's possible to upload the document. I'm having some difficulty uploading my presentation, but I can give it another shot.
Yeah, you have it enabled. You're able to share screen in terms of like from our side on the Zoom side. So is it? Are you just trying to like share screen, or are you uploading?
Yeah, that's correct. For some reason, I'm not having that ability. Is there any way, Steve, that you could share your screen, perhaps?
Sure.
If I send the document?
Yeah, go ahead.
Wonderful. I've just sent that over via email.
I have it. Opening now.
I also just, I'll jump in. I also just wanted to highlight the fact that you do incorporate companies, because I think some companies see that Wilson Sonsini has worked with Tesla and Google and thinks, well, I couldn't afford, I'm not ready to go approach Wilson Sonsini. And I feel quite the opposite as a VC, that every founder should have really good representation and good legal help. So.
Oh goodness. Well, no, I really appreciate that sentiment, Minnie, and I agree. In fact, actually, the incorporation can be one of the most important touch points for a founder and a company. Including without limitation, its IPO or its M&A. Just to give you an example, prior to this conference, I was having a call with a company founder who had another firm, set up their incorporation. Unfortunately, the documentation was not done correctly, such that it impacted the capitalization of the company, as well as what are called 83B filings, which we can touch upon during the course of this presentation. For the most part, these things can be fixed, but not without cost and expense, and not without some headache. And so, but certainly, being able to be there at the incorporation side using our standard forms that have been tested by venture and tested in the IPO market, I think certainly can actually long-term result in cost benefits as well as time efficiency. So yeah, thank you for that observation. We actually, in fact, one of the slides will just be an emphasis on our emerging company practice, which are led by Raj and Craig Sherman in our firm to create a startup portal. So thank you so much, Steve. I really appreciate your uploading that. It was likely some technical issues on my laptop. So with that, why don't I go ahead and I don't know if I can progress through the presentation, Steve. I apologize. Perhaps this is something that if you want to just bring up the slideshow, we can skip through the background of Wilson and go right to the substance if that's okay.
Yeah, I'm trying to do that. Sometimes mine actually also misbehaves every so often.
And in addition, for those who are participating, we'll be happy to make this presentation available, either online or by email. Just feel free to reach out to Steve and feel free to reach out to me if you have any questions arising after this presentation. And maybe actually to that point, the initial slide that I have, and the first few slides are primarily introductory relative to our firm and our emerging companies practice. But perhaps going directly to Minnie's question in terms of the type of entity to form. So let's just let's talk from square one, so to speak, which is you've now started a business or are starting to ideate a product and wish to create a limited liability entity so that you can issue shares, so that you and your team members can own a fraction of the company, as well as a home for your assets and your innovation and your business. And so one of the questions that we receive quite often is, should we establish as a corporation or a limited liability company? And for the most part, the answer is that it depends. There are situations where LLCs can be quite helpful, and usually this occurs in the context of, let's say, family businesses, services businesses, or in certain cases, investment vehicles for real estate and others. But for the most part, for companies who are looking to raise venture, the default is a Delaware corporation, and specifically a Delaware C corporation, for a number of reasons. The first of which is that, as mentioned, venture capitalists and accelerators prefer Delaware C corporations because it's a well-trodden path. The law is quite established, and the venture, the default venture documents, which we'll go into, are generally governed by Delaware law, such that there's a common language amongst the entrepreneurs, the investors, and their respective counsel as to the business terms that define an investment. In addition, for C corporations, and this is independent of where the entity is established, whether it's Delaware or somewhere else in the United States, there can be the ability to receive what's called qualified small business stock to founders and investors. And that qualified small business stock is an IRS concept, but the short of it is that those who hold shares in certain types of C corporations that engage in a certain type of activity can receive a fairly sizable tax exclusion if those shares are held for more than 5 years. And so that becomes quite attractive, not only to angel investors and investors, but also quite attractive to founders themselves. Unfortunately, neither LLCs nor S corporations are eligible for what we refer to as QSBS treatment. In addition, the issue of IPO pathway, as you probably know from your research of IPOs that have occurred, it's not a coincidence that many of the IPOs are Delaware corporations, and so it just makes it much easier for the investors and for the underwriters to be working with a Delaware corporation, not only from the standpoint of raising initial capital, whether it's founder stock, friends and family, but also ultimately towards an exit such as an IPO. Now, again, that's not to discount an LLC. An LLC actually has several advantages in the sense that it has a great amount of flexibility from the standpoint of structuring economic and voting interests and creating multiple classes that provide more flexibility in terms of perhaps more flexibility than a traditional C corporation, which typically just issues stock and preferred stock or common stock, setting aside convertible securities. And so LLCs do provide some more flexibility. They do have tax advantages relative to a C corporation. However, they're not a favored vehicle from the standpoint of raising capital. We do have very limited circumstances where perhaps a founder will come to us and say, why don't we first start as an LLC while we're harvesting losses associated with getting our businesses going? And then when an institutional investor comes to the table, we'll convert to a corporation. And certainly that can be an option that could be a viable one. Having said that, one of the things, and maybe a tip for the wary, is that these LLC structures can get quite complex, particularly if economic and voting interests are divided and don't really mirror a common stock or a C corporation type capitalization structure. And so it can be quite difficult to convert the LLC into a corporation at the point when an investor comes to the table and requires that as a condition to their investment. So just a tip for the wary that one can establish as an LLC. Conversion can occur in connection with an institutional investment. However, there can be complicating factors in terms of getting approvals and trying to have an apples to apples conversion of LLC interests to a corporation, to corporate interests, that can complicate the process and add cost. And so let's just say, okay, well, let's just say that we are now in the camp of establishing a C corporation, the thought being that ultimately the company wishes to raise capital at some point in the future. The next key point in terms of establishing the corporation and papering the ownership is to finalize the capitalization. Now, this can actually be a difficult discussion amongst, the founders as well as the employees, but it's an incredibly critical one because this is one of those areas where it's difficult to fix, if not sometimes impossible to fix, if capitalization is not memorialized in writing, and or if there are oral promises made about the issuance of stock that can have a serious effect on an investor's expectation of how much percentage ownership they're going to receive in the company, or the ability of the company to do an underwritten public offering in the future. So really getting a consensus amongst your core founding team on capitalization, who owns what, is helpful.
Hey Ken.
The second,
Sorry, hey Ken. I think we have your screen up. I mean, we have your slides up now. So
oh, wonderful.
which slide should we be on?
I really appreciate that. Thank you.
Oh,
Thank
sure,
you for
no, sorry.
So just by way of background, Steve, we're on slide 8, which refers to the first bullet under that is founders and capitalization.
Great, thanks. Now we're with you. Great. We'll just say
all right.
And slide.
The power of teamwork. I appreciate your help, Steve. Thanks so much.
Actually, my computer crashed. So a very powerful presentation.
Yeah, there's no animation in it, unfortunately. It's just a dry text. But I hope to be an animated speaker in that regard. So
you're doing great. Carry on. I'll pause I'll mute myself.
Thank you. Flattery is everything. So now I'll keep going. I'll try to be brief to open up the discussion for Q&A after we go through some of these points. So, once the owners have finalized what the capitalization of the company is, in other words, who owns what, another question that arises that can be a difficult question, but a very important one, is this issue of vesting. Now, what is vesting? Well, vesting basically means, in the context of founder stock, which is characterized as restricted common stock, that means that each of the founders actually own shares in the company. They receive shares in the company. But let's just say, let's take a hypothetical where there are 4 founders, each of them get 1 million shares each, and one founder decides to leave 2 months into the company. Then the other 3 founders feel that perhaps that 4th founder left prematurely and should not be entitled to receive the full benefit of a 25% ownership interest in the company. That's where this concept of vesting kicks in, and this basically allows the company to repurchase shares in the event that a founder leaves before the full vesting schedule is met. So under this hypothetical, let's take a 1 million shareholder, and let's just say we have a typical vesting schedule of, say, 4 years for each of the founders. If that individual then leaves 2 months into working with the business to find another opportunity or to start another business, then effectively none of those shares will have vested under a traditional 4 years vesting schedule, where 25% vests on the first anniversary of the date of employment, date of hire, incorporation, and then monthly vesting thereafter. Should that particular individual stick around for the full year, however, they would be entitled to 25% of the company. But then if that individual leaves, the company would have the ability to buy back that 75%, thereby reducing the number of shares that individual has and equalizing, so to speak, the capitalization of the company to reflect the founder's investment of a year of his or her time into the company, but not more than 3 or 4 years. So that's how restricted stock can be used, investing can be used to have alignment amongst the founders that they are really in for the long term to build value in the company. Now, one of the corollaries associated with restricted stock, as you may have heard or may have even filed, is this concept of an 83B election. Now, unfortunately, this is a hard deadline where an 83B election has to be filed with the Internal Revenue Service within 30 days of restricted stock issuance. And the thought here is that it basically tells the IRS that for founders who buy shares at presumably a very low price, given that these shares are typically issued at the incorporation of the company, that they will be paying taxes on the shares as of the date that the shares were originally issued, as opposed to when the shares vest. In the hypothetical we just described, let's say this one founder vests 25% on the first anniversary. The theory being is that a founder has a decision to make: pay taxes now on shares at a very low value that may not have value in the future, let's say if the company closes down, or pay taxes once the shares vest, but if the company does well and the vesting starts to occur on, let's say, the first anniversary after the company is now revenue positive or post MVP, the taxes associated with those shares could be much higher. So by and large, and every individual has to make this decision with their respective tax accountants. We've generally seen founders who restrict restricted stock make the 83B election, but it is one of those elections that need to be made within the prescribed period of time of the IRS. Cleaning it up after the fact can be quite difficult. The second component associated with establishing your business is really identifying who else is going to be on your team besides the core founder group. And one of the things that you also may have heard about or read about is California's challenges or California companies' challenges associated with characterizing individuals who work for the company as employees versus consultants. And you may have heard this in the context of kind of this ride share economy or this sharing economy where, for example, Uber drivers, Lyft drivers, and others are working for these companies as part of a gig, but not on a full-time basis. And so the California has a very specific test by which they characterize an employee versus a consultant. And one of the things that we occasionally see with respect to startups is not having their eye on classifying these individuals as employees versus consultants. And misclassification can have some significant liability going forward, particularly if the individual or individuals of a company later assert that they should have been classified as employees and entitled to the benefits of an employee versus being classified as a consultant. How else then can the team be formulated and motivated to help drive value of the company? Well, in the same way as restricted stock, where the founders have skin in the game through receipt of a restricted common stock, so too can team members who may not be, the original founder set, receive the opportunity to become owners of the company. And that's through the form of what is referred to as stock options. And that's something that is a well-trodden path in the context of corporations, and specifically venture-track corporations, to motivate employees to stick around with the company, help drive value, with the theory being that their stock options will be worth significantly more when they exercise the option than when they first start with the company. In order to adopt a stock option plan, though, it does require board and shareholder approval, and it also requires what is referred to as a 409A valuation. And this came in the context of the 90s, as you may recall, where companies were going IPO or backdating their options so that individual option holders could get a better, a lower strike price and therefore a better appreciation of their shares. And the IRS and the SEC both addressed this issue, and specifically 409A was formulated to provide a mechanism by which companies could rely on a third-party valuation to assess the fair market value of the common stock that an optionee will receive, and have that be something the board could rely upon as the fair market value of the company, in the absence of which there could be penalties associated or levied by the IRS to the extent that the options are granted at less than fair market value. But it is a consideration to take account for if a company or an entrepreneur wishes to grant stock options. It's an additional expense of adopting a 409A valuation. These are done by third-party outfits. Occasionally, it can be done by someone on the board, but usually there's very specific qualifications associated with that, and board members at the early stages or boards at the early stages of startup companies don't have board members with the requisite qualifications to be able to make a 409A valuation on behalf of the company. So they'll outsource it to smaller investment banks or sometimes to shared ledger services like Carta to create that 409A. But very important to obtain not only board approval and stockholder approval to adopt the plan, but also board approval of each and every stock option pursuant to the plan and in reliance on a 409A. That's another mistake that we see occasionally with some companies, where it can be quite difficult to remedy the situation, particularly if the price of the company or the value of the company and therefore the price of the stock has escalated since the time that the stock option or the recipient thought that they had received their stock option. So going to the next slide then, another consideration, and this is particularly true of many of the companies, both in today's session as well as yesterday's session, that really rely on and create some innovative intellectual property and inventions to be able to drive business and to onboard customers. So another consideration to factor in is owning your intellectual property. And this can occur at the very inception of the company when the company is formed. So it's not atypical. In fact, it's fairly standard to have founders assign intellectual property associated with their business plan, or sometimes they may even have pre-existing intellectual property that's valuable to the company, this limited liability entity that we're talking about that will be the home for your business. And that is done through an IP assignment, typically at the time that the shares are issued and or, in the case of the founders, upon inception of the company. And then going forward, the founders, the employees, and the consultants, and really anyone who is creating intellectual property for the company would sign what we refer to as a proprietary information and inventions assignment agreement, and that's a PIIA. You also may have heard it as a CIA, which just means confidential information. The net effect is the same. It basically is a document that investors will look for because they want to make sure that the company, that the founders have assigned the requisite IP to the company. And then going forward, not only the founders, but the employees, the consultants, and anyone who has touched the intellectual property of the company or developed the intellectual property of the company have assigned that IP to the company. And that's what a proprietary information and inventions assignment agreement does. It basically specifies that for anyone working for the company, when they're developing that IP on behalf of the company using company resources and on company time, that will be owned by the company. The other component of the agreement is that they agree to keep the company confidential information confidential. And there can be other bells and whistles of the CIA and the PIA that we can get into during the Q&A if needed. Another thing that we've also noticed, particularly with tech companies and even life sciences companies, is that some of the development work, whether it's on an app, whether it's on an invention, whether it's on a development of a drug, it can be outsourced not only to domestic third party companies, but also international third party companies. And this can come up as a diligence issue as well, where let's just say that a company has contracted to do some really critical work relating to the development of software to a European country or an Asian country or country outside country that an investor is not familiar with and the investors council is not familiar with. It's very important then to weigh for the entrepreneur the balance of hiring local counsel in that jurisdiction to make sure that the contract is enforceable in that country where the developer is located against the risk that using just a US form or having no form at all will create a diligence red flag, if and when that company later goes out for financing. Because it all goes to the narrative of making sure that intellectual property created on behalf of the company is owned by the company. Similarly, the other important component for many of the companies that are on this conference call, as well as during this conference, is protecting intellectual property. And you've heard, I'm sure, of different mechanisms to accomplish that, whether it's patents, copyrights, trademarks, domain names, and trade secrets. And so we won't go into that in great detail, but it's something that a company, particularly a technology or life sciences company, should evaluate at the inception of the company and even budget, from a timeline perspective and from a monetary perspective, how they go about creating their IP portfolio. In the case of life sciences companies, this can actually be a critical component of valuation of the company. And even in the case of technology, software, and others, it's an important discussion to have. As you may know, sometimes decisions are made with respect to software not to patent the technology, because once the patent is filed, it becomes public information. Versus weighing the advantages of having a patent, let's say on particular aspects of the software that will allow the ability of the company to block others from infringing that patent. So it's a worthwhile discussion to have. And the nice thing is that the U.S. Patent Trademark Office does provide for kind of cost-saving measures, such as the filing of a provisional patent that may may reduce some of the upfront expense associated with filing a patent while a company is getting going and starting to raise friends and family financing. Similarly, copyright and trademarks and domain names and trade secrets all go to this basket of what are the assets of the company. And certainly, while a decision may be made by the company that certain aspects of IP are more relevant than others. So for example, a consumer-facing portal, a trademark may be much more important than trying to find a patent for a widget within the portal. That's a helpful discussion to have, and a good IP attorney can help you through that process. One last consideration, although certainly not the only consideration, is when the company decides to use third-party intellectual property or is approached by another third party to create a joint venture or do a development deal. In the context of software, for example, if a company uses open source software, care will need to be taken to make sure that the assets or the unique IP developed by the company are continued to be owned by that company, as opposed to having other third parties use that and decreasing the value of the competitive mode associated with that intellectual property. Similarly, for development deals, which may seem very attractive at the early stages, where maybe it's a 50-50 joint venture or a co-development deal relative to a core aspect of your company's intellectual property, if those definitive agreements are not clearly drafted, and if they're not done with specificity as to which party owns which component of the intellectual property, it can be very, very challenging after the fact to unwind, particularly from an investor's eyes. If, let's say, it confers joint ownership rights, or even worse, it means that your company has given up a substantial part of its intellectual property assets that it was not previously anticipating. Another consideration as you start your business and even as you begin your MVP and socialize your revenue model is onboarding customers. Now, depending upon the type of industry, onboarding customers can be quite a process. So, for example, for institutional, thanks so much, Steve. I'm currently on slide 10, which has the first bullet referring to customers. And so, for example, part of the goal and part of the tension, frankly, of onboarding customers is to reduce the friction associated with onboarding a customer, so that the company can establish traction in the eyes of an investor and either create the revenue or create the user growth that's helpful to justify a pre-money valuation that will not create excessive dilution. And so for SaaS companies and other companies, a beta test or beta license can be one way to onboard companies to get them interested in the product with the goal of achieving a larger, and a paying longer term relationship with the customer. But outlining the beta license, particularly if your customer is going to be providing feedback, or if your business model is evolving, I think having a fairly well-drafted beta license will be helpful in that regard. In addition, if your business is customer facing, let's say it's a website or it's an e-commerce play, really, or frankly, more recently an NFT play, or anything that where data is being harvested or collected from users, or where transactions are occurring on your platform, having a robust terms of use and privacy policy can be quite effective. And necessary. And we've seen situations where, for example, companies are bootstrapping and they'll kind of take the terms and conditions or terms of use from other websites of comparable companies and kind of cut and paste. But depending upon your business model, it may be an apples and oranges type terms and business, and therefore the terms and the privacy policies don't quite fit. And we've also seen situations where certain filings need to be made with regulatory agencies to be able to obtain some of the protections associated with the privacy policies and the terms of use that aren't made, such that some of the provisions of these documents, even if posted on the websites, are ineffective. Finally, as you start to onboard customers, there's always this challenge, whether it's a government customer, whether it's a private individual, whether it's a company, of how to structure that customer relationship. And having worked with a number of companies in all industries, it's very fact specific. So, for example, working with the government, generally speaking, you're working on their forms, and it's a very long process. But it is helpful to have someone who is well versed in reviewing government contracts, to take a look at the documents to make sure that, for example, intellectual property is clearly identified as being owned by the company, and other such facts. And there are many law firms, including ours, that have really good government contracting attorneys that can do that. Similarly, there's always the battle of the forms, or there can be a battle of forms that occur between a startup and a big company, and where the startup wants to use their form, let's say a SaaS subscription agreement, and the big company comes back and says, no, all of our vendors have to use their specific form. And so navigating that process and understanding the limitations and the parameters of what customers expect from startups of innovative technologies can be a very helpful exercise as well, so that there isn't friction associated with trying to get the deal done. One of the things, though, looking at from an investor perspective, that comes up in the context of diligence when we represent the investors, for example, is looking at these customer contracts to ensure that there are contractual provisions that don't expose the company, and therefore by virtue of the VC as an investor, to too much exposure. And that includes having things like limitations of liability, where maybe the customer is paying for a certain good or service, but if there isn't a cap on how much the company has to pay if there's a breach of contract or something that goes wrong, that can expose your company to a significant amount of damages in excess to what the customer paid. A similar situation with indemnification, and this comes up also in the context of IP indemnification, where the customer may want some assurance and indemnity that your IP does not infringe other third-party IP. And of course, payment terms is always a critical component, where it's very important to identify clearly the milestones and the triggers by which your company will be paid for the services or products it provides. And so, maybe the general takeaway at this inflection point of the presentation, and this is probably a cliche, but coming from a lawyer, but always get things in writing. And I think one of the things that is really critical, particularly for fast growth companies and for companies that have been bootstrapping, is to not have certain documentation in place, whether it's at the founder level, whether it's at the employee level, or whether it's at the contractor level. And what we found, because oftentimes we'll come in to review either as investors counsel or as part of a company who is now looking to raise capital, that it can be more work and more time to fix these issues if they're not in writing than had they been in writing in the first place. And this is also true with respect to your vendors and your suppliers, your resellers and distributors, particularly when it comes to critical components, when it comes to your supply chain, when it comes to your ability to resell product, and exclusivity that may be attached or requested by resellers and distributors with respect to your products. All of these things, I think, are important considerations to take into account as you scale your business, because they can sometimes serve as a thumb on the scale if the contracts themselves are tilted in favor of the other party, such that you can't execute your business model as quickly or in the manner in which you wish it to be. Certainly, and we'll get to financing concepts in a bit, but certainly getting a line of credit from a bank or from other types of lending institutions can be helpful. Noting that generally speaking, if the company is not meeting a certain revenue threshold, they will be asking for personal guarantees on lines of credit. So it's something that a founder will really have to evaluate in connection with bootstrapping the company and going out and getting a loan, because number one, it's a big decision to make for the entrepreneur. Number two, it's usually a personal guarantee made by one individual or one founder, as opposed to the entire founder class. So it's a discussion that we had. And number three is how that loan is going to be handled when new investors come to the table. Will that loan be paid off? If not, what's the mechanism by which the founder is kind of released of their personal guarantee as the company starts to scale? And that's also true of real estate leases and others, making sure that the leases are market, that they don't raise a red flag from an investor perspective as being perhaps above market or for more lease property than the company really needs, or alternatively for not as much lease property as for to the extent that the lease is too small to support the growth of the company. Lastly, another diligence item, and this is diligence in the context of an investment, but it just as a matter of course through the company's operation can be helpful, is ensuring that that the company remains proactive in terms of identifying pending or threatened litigation, and then particularly relative to investors disclosing the litigation. And we'll get to some of the documents that reflect the contracts between the investors and the company, but disclosing litigation and getting investors comfortable to the extent that it occurs, is really critical, because that's another big ticket money item that can have a chilling effect on investors. In addition, obtaining insurance can be quite helpful as well, just as a matter of practice. And it's not atypically investors, whether angel or venture, will require a certain degree of insurance to be obtained and or maintained by the company. So now going to the next slide. Again, not to reiterate, it is very important, particularly in the context of corporations and limited liability entities, to have the appropriate documentation in place to make sure that that the proper procedures are being taken to maintain the limited liability status of the company. So in other words, one can form as a company, one can create a corporation or an LLC, or particularly a corporation, but if none of the corporate formalities are met, the board isn't convened, the board doesn't take action relative to material actions, the stockholder actions are not obtained. It can be something as what's seemingly minute as not having, signing in the founder's individual name as opposed to as an officer of the company. All these things add up to potential exposure to the individual shareholders themselves, to the extent that it's later challenged to say, well, yeah, the corporation was established, but it didn't walk like a duck or talk like a duck. And so therefore, we're going to just treat it like a partnership, thereby exposing each of the shareholders to personal liability. So really finalizing and keeping track of the documentation relative to the company and its assets can be extremely helpful, not only just as an operational matter, but particularly as you start to scale towards institutional round or venture capital round. And that includes, as mentioned, the capitalization table. Very helpful to have that up to date, so that there's no confusion on the eve of venture financing as to who owns what, and because that can create nervousness on the part of the investors. Similarly, Investors Council will ask and review the board minutes and meetings, just to make sure that all of the boxes have been checked relative to proper corporate governance. That also applies to stockholder meetings and minutes. Stockholders, and board, typically would convene on an annual basis, whether telephonically, by video conference, or sometimes by consent. And then the board would meet and convene or review material actions as they arise. Sometimes there are quarterly board meetings, particularly for venture track or venture-backed companies. Another thing that sometimes gets missed in the context of running the day-to-day business is just regulatory filings, and we won't get into that in detail. But for example, every time a share is issued, or an option is issued, or even a convertible note or SAFE, that's an issuance of a security. And so Investors Council will want to see that the appropriate notices have been given to the governmental agencies, both federal and state, that the company has relied upon an exemption available, so they don't have to register those securities. This is maybe not as legal in nature, but certainly having some mechanism by which financial statements and records are maintained, whether in-house or by a third party, can be quite helpful as well. And the reason why all this documentation is important, not only from protecting the limited liability status of the company, not only from the perspective of smoothing the pathway for the founders to have comfort that the assets are being all housed within the company, but it is particularly relevant when you have an investor come to the table, because oftentimes the preparedness of the the written documentation can be a signal to an investor as to how, what processes are in place to maintain corporate governance and proper bookkeeping. And so if the records are a mess, it can potentially delay and sometimes derail financings. Because as part of the process in terms of investment, Investors Council will ask for what's called a data room, and they'll ask for all the documents, all the things that I just described during the first half of this presentation. And if the company is not ready with those documents, or if those documents are wrong, that can create some negative signaling to investors. Now, let's just say that you have all of these pieces in place and that you're ready to go and speak to investors. Let's just chat a little bit for a few minutes about the types of investments that you could potentially explore with your investors. Now, my colleague Zach had done an excellent job of describing some of the mechanisms by which a company can raise capital. So I'll touch upon this at a high level, and then we can always revisit the specifics in a subsequent call or subsequent meeting. But the general concept is that, and why don't we go, Steve, to slide 13, which is a graphic depicting the difference between common stock and preferred stock. So in general, founders and employees receive common stock. And common stock basically has a fairly low fair market value as determined, for example, as I've referenced before, in connection with the 409A valuation. And then investors will come in with what is called preferred stock. Now, preferred stock has elements and rights that are separate from common stock. Maybe most notably that preferred stock gets paid out first upon a sale of the company before common stock gets paid out. And as a result, and preferred stock investors can also negotiate a basket of rights which enable them to have governance oversight over the company by virtue of being on the board, blocking rights relative to material actions of the company, and so forth. And so as a result, the price of preferred stock and the price of common stock can be quite different. And that spread can be anywhere between 20% to, at the early stages, the spread between the price of common stock and the price of preferred stock can be quite large, which is good from an employee perspective, because that allows the company to be able to grant stock options at a relatively low strike price as opposed to the price negotiated by a preferred investor. As the company starts to mature, the spread between the price of the common stock and preferred stock decreases. The theory being that these rights are there's not as much of a premium associated with these rights. So then going to the next slide, one of the questions that investors may ask as part of the basket of their initial questions is, what does the founder think the valuation of the company is worth? And when they ask about what does that mean in terms of what's your pre-money valuation, or what's your valuation? Let's just give an example of what a pre-money valuation is. So when an investor says that they want a 25% stake in the company for 10 million, what does that exactly mean? Well, that means that the pre-money valuation of the company is 30 million and the post-money valuation is 40 million. Now, post-money just means after the investment is made. And it's actually an important distinction, because if you're in a fortunate position of receiving multiple term sheets, and one of them has a higher number, but it's post-money, and one of them has a lower number and it's pre-money, it's very important to compare apples to apples as to what is exactly the valuation that these VCs are and these investors are pricing at. Now, certainly there are multiple variables associated with pre-money valuation, among which is the growth rate, including revenues and users, the technology, the team, the market opportunity, and the IP portfolio. And sometimes valuation will also vary depending upon whether there are multiple investors who are vying for either a lead investor position or to create a syndicate. But in general, I mean, for SaaS companies, for example, there's a very stepwise progression in valuation, with where each series of preferred stock that's obtained, you're looking at roughly double the valuation, and each investor or each series taking anywhere between 15 to 25% of the company. So as the company starts to raise multiple tiers of financing, the entrepreneurs will just have to factor in the fact that with each series of priced financing, there'll be dilution to the company. Now, before a company can even get to the table with an institutional investor, oftentimes what we find is what are called friends and family investments. And the goal of these two instruments, which are convertible debt and safes, are to reduce the friction associated with taking in that capital. The theory being is either A, at the early stages, an entrepreneur is looking at friends and family who may be investing in the person as opposed to the technology. And B, to the extent that they are angel investors, they may want a lower valuation, because they just take into account that a number of companies at the early stage will not make it through, and so they want to be rewarded from a risk premium by getting a lower valuation. And because it's at a lower valuation, then that also means that ideally from a company perspective, you want to reduce the friction to take that money in and reduce the legal documentation and the back and forth that occurs as a result. And convertible debt and safes are kind of instruments that allow a company to do so with fairly minimal negotiation. A convertible debt is a promissory note. It can be a no purchase agreement and a promissory note, maybe 10 to 15 pages in length. Interest rate is set. It is debt, so it has to be paid back. And generally speaking, for most angel investments, it's unsecured. It would be very unusual if it was secured. And then a discussion has to occur as to whether or not that debt has a cap or not, which basically imputes a valuation. So one of the advantages of debt is you don't have to impute a valuation, but a cap essentially is a negotiated term within a convertible note where both the company and the investor says, okay, this note will convert at a future financing event when you raise institutional capital at a certain monetary threshold, but the investor gets either the benefit of a discount on that preferred price when the note converts, or the investor gets the notes converted at a specified valuation. And so that's just a discussion and commercial discussion to occur to the extent that a cap is part of the negotiation. Safes are actually even more simple documents. They were really intended to further reduce the friction associated with convertible notes. These are typically 3 to 5 to 7 page documents. There's no maturity date, unlike a convertible note, and no interest rate. And it is a short form document that originated out of Northern California. And as such, there's not as much familiarity within Southern California as the SAFE instrument, although we are starting to see it be used quite often as a bridge to an institutional round. So then if we go to slide 16, this goes to the issue of, okay, now you've raised your friends and family round. You're revenue positive or you have good traction and you want to go out to institutional investors. Well, it is possible that the institutional investors will be comfortable investing in a convertible note and or SAFE, but not probable. Typically speaking, VCs will want to structure their investment as preferred stock. As mentioned in the prior slide, that preferred stock is senior to the common stock and has certain bells and whistles that allow that investor to have greater insight to the company and greater oversight of the company as a result. And so, as you may expect, the great thing about venture capital is we do have some excellent forums that are online that articulate typical preferred financing at the early stages, at the Series C stages and Series A stages, and those resources can be found on SeriesC.com and also through the National Venture Capital Association forums. Again, Series C is typically helpful at that very first institutional raise, or sometimes in maybe a more sophisticated angel range, because it is short form. We're talking about maybe 20 pages worth of documentation, which really just defines that yes, the preferred stock is senior, and yes, the company is making limited reps and warranties, but there's not many more bells and whistles that preferred investors get. Sometimes they get a board seat, sometimes not. But it helps reduce the friction on the lawyer side to have a standard form that's been used and tested in these deals. And so negotiation tends to be minimal on those documents. The second document is something that one would expect from a Series A investor and sometimes a Series C investor, and that's a National Venture Capital Association form. Now, instead of 20 pages, we're talking about several hundred pages. And because there's so many pages to it, there's a lot more to review. There's more disclosure that has to be brought, that the founder has to provide or the company has to provide because they're more extensive reps and warranties. And all of these pages kind of go to the rights of the preferred investors relative to their investment, meaning that they get more than just the ability to get paid out first. And slide 17, which we won't go to in detail because we do want to have an opportunity to address any questions, are just some of the data points associated with deal points that arise in negotiating equity financings. So one of the things that as an entrepreneur you'll want to be cognizant of is that a VC will present a term sheet if they're interested in investing in the company. And that term sheet will define what the terms of the investment are. Sometimes it's a convertible note deal, more oftentimes it's structured as a preferred deal, and it will include a number of these provisions that I outlined in this slide. And that goes to valuation, that goes to the liquidation preference, which means their ability to get paid out first, and whether they can participate in any remaining proceeds after they get their 1x plus interest. That refers to things like their ability to get anti-dilution, and it also can refer to some of their blocking rights, protector provisions, where the company has to get the permission of a group of investors before they can take material actions like sell the company, maybe raise new capital, and other material actions of the company. It will also set forth things like who's going to be on the board. And that's actually a very important discussion to have at the Series C to Series A level, because it sets the precedent for future fundraisers in terms of who's going to be on the board, and of the board members, how many are going to be represented by the founders. And so bear in mind that with each successive preferred stock funding event, there is a possibility that a new board member has to be added. And with the average size being 5 to 7 board members, pretty soon that board, the number of seats that are open for the founders can decrease over time. So it's certainly something to think about, but they're well-trodden paths in terms of articulating and working with the investor group to formulate an ideal board to get to the next inflection point. Some of these other items we can chat about, or we can be available to chat about later. But the nice thing is, relative to venture financings and IPOs and M&As for that matter, there's a tremendous amount of data that's out there in the public domain, and we've been really fortunate to have represented so many companies and investors in venture capital, M&A, and IPO that we will be happy to share market trends and market data, among which, if we go to slide 18, are our quarterly emerging company or venture capital reports. And so we'll share, and it's a PDF that's accessible on the ECP website that we provided a link to, or that we can provide a link to should you request a copy of the presentation. Well, quarterly will tell you what the trends are, what we're seeing in the marketplace, and even on a more granular level, there are very specific ranges of terms that are considered market within these venture capital investments. And now they are fact specific in the sense that different industries can have different terms, different stages of investment can have different terms. But as an aggregate, we're able to provide some data that can be helpful in determining and assessing what a term sheet, whether a term sheet is market or whether a term sheet is not market. And so having gone through these slides very briefly, these are just some of the financing trends that we're finding based on our last quarterly report. And certainly it's reflecting that the ecosystem for financing is quite robust. And we can also affirm that at a personal level in Los Angeles, that the funding environment is quite robust. Hopefully this presentation has been helpful to the team here. And again, the whole goal and the ideal goal of a lawyer or legal documentation is not to create obstacles to getting the deal done. The objective of this presentation and a transactional lawyer in general is to be proactive in terms of putting together the right documentation in place so that when an investor comes to the table, an underwriter comes to the table, or a buyer comes to the table, they look at the documentation, their lawyers take a look at the documentation, and there aren't red flag issues that can delay or potentially stop the deal from occurring. And so, again, to reference it a third time, it's always good to have these documents in writing and to address these commercial terms amongst the founders and amongst third parties up front. And that helps any subsequent investors or parties who come to underwriters and buyers to really understand the legal landscape of the company as they encounter the data room. So with that, I'm open to any questions that you may have, and thank you so much for your time.
Hey, Ken, I think I have a question here from the audience, and I'll read it. If the founders are putting in up to $500,000 to get a minimum viable product for a software company, A, is it reasonable to then jump to a Series A of $20 million or so for growth and marketing expenses, and B, to bring in Wilson Sonsini a few weeks before the minimum viable product is complete? The company's already registered as a Delaware Corp. So I got two kinds of questions there.
Great questions. And, the typical lawyer answer is it depends. I mean, I think that at the end of the day, let me answer this in two parts. The first of which is, yes, having a minimal viable product is mission critical in many cases, unless the founder team or the management team has executed in a previous business and there's confidence amongst the investor group that pre-MVP, the founder team is able to identify and monetize a particular market. So MVPs can range from 50,000 to 500,000 to much more than that in the case of life sciences companies. So the short answer is it is very helpful to have an MVP. It's a good signal to prospective investors and strategic partners that the founder team is putting skin in the game and that they are creating a product. It's also helpful to, if possible, test that MVP in the marketplace to make sure that there's early signs that the customer has reviewed it and that they're willing to use it and ultimately to pay for it. So that I think is another helpful data point to have. I'll have to defer to my colleagues, Minnie and other VCs in terms of a Series A of 20 million or more. And every industry is different. Life sciences valuations are different and criteria are different than, let's say, SaaS software companies. But for example, for a SaaS software company, which has, can have very high margin and high scalability, generally speaking, if you're looking at a pre-money valuation, not a capital raise, but a value of the company of between 15 to 25, there'll be an expectation that the company is generating, a couple $1 million of annual recurring revenue per year. With robust growth. Now, obviously, that can be variable depending upon the management team, the size of the marketplace, the velocity of growth, and so forth. And so that I'll defer to my colleagues on. And then, in terms of Wilson Sonsini, I'm happy to have that discussion offline. One of the things that we can do as well is we can kind of take a look at your books and records and do an audit or kind of do a checkup to see if some of the items that I described during my presentation are indeed in place. Because sometimes what we've seen is two things. Number one is if the investor flags the diligence issue, that's a negative signal. So it's always good to be ahead of an investor flagging the issue for the company. And then secondly, sometimes it takes more time than anticipated to fix these issues even before going out to a VC. And so things like capitalization, things like intellectual property can take sometimes weeks or even months to fix. So it's always good to have the house in order before going out to a VC.
Great, thanks, Ken. If anyone else has any more questions, please do put them into the Q&A in the Zoom. One question did come in about sharing the slides in the video, and I believe you have agreed to generously let us publish or distribute these slides to all attendees. Is that okay? Okay.
Absolutely, and thank you, Steve, again for driving the presentation. I really appreciate that. And hopefully, during the first half of the presentation, if there are any questions that the participants or any of you may have where you didn't have the benefit of seeing the slides, feel free to review the slides and reach out separately.